Hello everyone. Before we start today's video, if you could all do me a solid and lightly tap the like button, perhaps share the video about and leave a comment. If you are not subscribed, subscribe as well. It would greatly help this channel. Thank you very much. Well, isn't this just fantastic? Captain's log, subdates 220719.7. How on earth did things get 1 degree hotter? We're hardly anywhere near topside and nowhere near a tectonic edge. Has someone tampered with my environmental systems? Because I'm starting to think shenanigans are involved. Hello everyone, welcome back to another El Scorchio video. And by El Scorchio, by UK standards, it's bleeding warm. Warm enough that, again, we're doing this visual, sorry. But I really can't have my computer on all day. My room would turn into a hot box. Today we are going to talk about Amber Heard's attempts to try and change the outcome of her loss. The loss that many of you know about, to Johnny Depp. Consequences obviously felt. She is still going to be dealing with this for quite some time. The insurance company paying her settlement, no doubt. Yeah, this is going to get very spicy. What happens again if you don't pay it? Is it prison time? Do they have aircon? El Scorchio be defeated by aircon prison. The more notable thing that Amber Heard is trying to do at present is to have the verdict of the defamation trial thrown out and to have a retrial because the juror, one of them, 15, was deemed by the attorneys involved, defense, as illegitimate. Many of you pointed out in my last video on Amber Heard, and yes, I did read all these comments, that each and every juror was screened not just by the court but also by both legal teams, meaning they saw all the pertinent documents, they saw the people involved, which meant they knowingly still allowed this juror to take part. Responsibility is on you guys as much as it was on the courts. If there was a problem originally, the problem should have been brought up sooner. That is the argument. If there was a problem, it shouldn't have been waited until after a verdict had been already passed from the juror to the judge to you, along with all other consequences. Thank you to everyone, by the way, that told me this. I didn't know it, and I genuinely am very grateful that you had told me, so I can add this to this playlist as well, to ensure that all relevant information is known by all that watch them. So a judge who has been looking at these 3 motions that Amber Heard's legal team have filed has denied all of Amber Heard's motions to have the verdict thrown out and retried. The lawyers that represented Amber Heard filed a motion earlier this month on the grounds that the verdict that she defamed Johnny Depp was not supported by evidence. They also alleged that a juror had not been properly vetted and questioned whether the juror was even supposed to be allowed on the jury. Judge Penny Asgarati denied all of these post-trial requests on Wednesday. In a 43-page memorandum that many of you heard about in the last 2 videos, Amber Heard's lawyers argued that the verdict and the damages should be tossed out on the grounds that during the trial, Johnny proceeded solely on a defamation by implication theory, which abandoned any claims that Amber Heard's statements were actually false. Amber Heard has also said that she is unable to pay the $10.35 million in damages that she owes Johnny Depp. Now, Johnny had offered you a way out. You had been found to have defamed him. He was after a paltry $50 million. You, for your countersuit, were after $100 million. You got $2 million because one of the lawyers representing Johnny had defamed you. Yes, Johnny got 10.35. It would have been 15, but the statute limiting whatever took it from 15 down to 10.35. Your insurance company don't want to pay that and are arguing certain limitations apply depending on state. That is going to be tasty to watch unfold. After the original verdict, Elaine Bredhoft, the lawyer representing Amber Heard, had said that Amber can't afford this. She really can't. She also cannot afford an appeal. And we now know this for certain because to lodge an appeal, she would have to fork up $10.35 million as a bond, upfront, full amount, to then get the chance of an appeal. But as her net worth is negative $8 million, I don't think she's going to be able to do it, not unless she's able to get a loan off someone really wealthy and stupid. But Johnny had offered you a way out. The way out was simply walk away. Walk away now, accept the L, go be a mother, continue your acting career, let's continue our lives, and you, in an interview, gave off not an iota of an impression that you felt any remorse, guilt, shame for your absolute lies. All of which were proven on the stand. You are still memed heavily for your performance on the stand, because your over-the-top reactions and gestures made you look like a complete and utter tool. So one of the motions casting doubt on the validity of the jury selection process pointed out that the juror identified as Juror 15, birth date was listed as 1945 in the court records, but the filing argued that Juror 15 was born later than 1945. Publicly available information demonstrates that they may have appeared to have been born in 1970, with them saying that the discrepancy raises the questions whether Juror 15 actually received a summons for jury duty and was properly vetted by the court to serve on the jury. It appears his identity could not have been verified. On the screen now is the court judgment from Judge Penny Ascarati, denying Amber Heard's motion. Here we have, this cause came before the court upon defendant Amber Heard's post-trial motions. After review of defendant's post-trial motions, plaintiff's opposition, and the relevant statutes and case law, it is therefore ordered as follows. Defendant Amber Heard's post-trial motions 1 through 6 are denied for the reasons stated on the record. Defendant Amber Heard's post-trial motion 7 is likewise denied for the reasons outlined below. The purpose of voir dire is to obtain a fair and impartial jury. Voir dire is necessary to ascertain whether any juror has any interest in the case or any bias or prejudice in relation to it, and that he in fact stands indifferent in the cause. The summons issued for Juror 15 listed his legal name and address, and no birth date was noted. The court has pulled Juror 15's jury questionnaire, attached and redacted filed under seal. Juror 15 completed the jury questionnaire as himself filing in his proper birth date. The information presented on the jury questionnaire matches the information Juror 15 provided to the court. Juror 15 was vetted by the court on the record and met the statutory requirements for service. The parties also questioned the jury panel for a full day and informed the court that the jury panel was acceptable. Therefore, due process was guaranteed and provided to all parties in this litigation. Voir dire was conducted in a fair and impartial manner, with the court and both parties examining the potential jurors. There is no evidence of fraud or wrongdoing. Further, the defendant was provided the jury list 5 days prior to the commencement of trial and knew or should have known about the mistake at any time during the 7-day pendency of this trial. She had every opportunity to object to or to voir dire on the issue. Parties must make objections at the time a ruling or order is made to put the court on notice that an issue is meant to be preserved. Despite defendant's assertion in footnote 9 of her motion, quote, "Any error in the information shown on such copy of the jury panel shall not be grounds for a mistrial or assignable as error on appeal, and the parties in the case shall be responsible for verifying the accuracy of such information." That quote is from Virginia Code. Consequently, defendant as well as plaintiff had an affirmative obligation to ensure the accuracy of the information provided for the jury panel. A party cannot wait until receiving an adverse verdict to object. For the first time on an issue known since the beginning of the trial, the issue has been waived. Even if, argumendo, the objection has not been waived, objections to an alleged discrepancies in jury lists and any legal disabilities of potential jurors must be made in accordance with Virginia Code. That section provides, in relevant part, unless objection to such irregularity or disability is made pursuant to subsection A herein, and unless it appears that the irregularity was intentional, or that the irregularity or disability be such as to probably cause injustice. In a civil case to the party making the objection, then such irregularity or disability shall not be cause for summoning a new panel or juror, or for setting aside a verdict or granting a new trial. Virginia Code, and then all those bits there. Furthermore, while parties must make this objection while following the above procedure, the party moving under this code section must provide some evidence of prejudice. Defendant has neither followed the proper procedure nor shown evidence of prejudice. Defendant does not allege Juror 15's inclusion on the jury prejudiced her in any way. The juror was vetted, sat for the entire jury, deliberated and reached a verdict. The only evidence before this court is that this juror and all jurors followed their oaths. the court's instructions and orders. This court is bound by the competent decision of the jury. Signed, Honourable Penny S. Ascarati. The judge herself has indicated that she does not want this to continue, which is why she dismissed it all. But if they do want to make an appeal, they can of course go ahead and do that with another court. Part of me thinks she's going to bring this to the UK because we're a bit sympathetic to her plight as a poor defenseless woman that's beaten every single partner she's had in the past. Allegedly. I know Amber Heard might be hedging her bets with a tell-all book, but I would advise against it, Amber. Take the out and the L while you still have the chance. A tell-all book could be seen as further defamation of what you've done. Further defamation where everyone doesn't believe you anyway, and the only people that are going to buy your book are just going to upload all the pages online so no one else wastes their money buying it. It's unlikely to make the money you need to then be able to pay this legal fee. Take the L, and then you don't have to pay the money at all. You get to keep the money you currently have, and you can, well, what little money you have, and raise your child in a healthy, safe, financially stable environment. You're putting the priorities of your selfish narcissism, which sounds like the same thing twice really, doesn't it, over that of your more important priorities. And you have more important priorities, Amber. The judge has smacked you down, take it, and move on with your life. I don't expect you to do it, because you are arrogant enough to truly believe you're still in the right. You defamed him, and in that trial, he still proved you were the abuser, not him. Move on, please. This is getting embarrassing now. As we've reached the end of the video, I'm going to take the opportunity to promote some things. Firstly, there's a new video on Moisky Reads. Yes, I have a channel where I do readings of poetry and short stories. I'm going to try and do longer ones when it cools off in the autumn. I have a channel called Omegon YT Electric Boogaloo where I upload other exclusive videos to that channel. And if you'd like to help me finish my log home, I have a coffee link down below. Please consider helping me as I try and get solar power sorted out for it, as electric costs far too much. Thank you.